reflecting to the importance of implementation of the judgments of the European Court of Human Rights, which is one of the essential problems of our organization. During yesterday's discussion, the President of the European Court of Human Rights stated that during the last 60 years, the Court has delivered over 26,000 judgments. However, as of March 2023, more than 6,200 of judgments of the Court have not been implemented and are still pending before the Committee of Ministers. This means that nearly 25% of the Court's judgments have not been implemented by the Member States, and this is a serious problem. The implementation of the interim measures issued by the Court is also of high importance. However, despite this, the Committee of Ministers has lack of power in this respect. I would like to remind you that the conditions for memberships for Council of Europe are pluralistic democracy, the rule of law and respect for human rights. Only those countries which fulfill these criteria can accede. And the European Court of Human Rights is the only abiding mechanism which is supposed to guarantee at least one of the three conditions of membership of this organization, the respect for human rights. Not implemented judgments undermine the authority and functioning of the convention system. This is why we must reaffirm the binding nature of the judgments and decisions on interim measures of the European Court of Human Rights, further reinforce the execution of judgments by strengthening relevant cooperation activities and enhancing the means at our disposal in cases of non-compliance. Colleagues, what your respective states do when your citizens do not implement judgments of your domestic courts. You enforce the implementation, you apply sanctions. But what we do as a Council of Europe when a member state refrains from implementation of the ECHR judgments? We just acknowledge the fact and do not take necessary steps. During the last 10 years, Council of Europe member state Azerbaijan has not implemented nearly 80% of the ECHR rulings. This country is the leader among the member states of the Council of Europe in terms of the number of unexecuted judgments, and the statistics show that the number of non-implemented decisions by Azerbaijan is increasing year by year. This is a pure disrespect for human rights. This country neglects not only the rulings of the ECHR, but also those of other international courts. For example, the binding order of the ICJ, which obligates Azerbaijan to take all measures to ensure unimpeded movement of persons, vehicles and cargo along the Lachin corridor in both directions, is still neglected, and Azerbaijan continues blocking the road of life for 120,000 people in Nagorno-Karabakh, thus creating a humanitarian catastrophe. Ladies and gentlemen, we cannot ignore the shameful statistics of the unexecuted judgments. And when I say shameful, I mean it for this Council, because it shows that this organization should have taken proper actions in either introducing of new mechanisms for enforcement or by thinking about sanctions, including suspension of membership of states, which make zero effort to comply with the conditions of membership. In this case, the respect for human rights. Thank you.
Thank you very much. Next speaker is Bertrand Bouyux, France.
Merci, Monsieur le Président. Chers collègues, l'article 46 de la Convention européenne des droits de l'homme est très clair. Je cite « Les hautes parties contractantes s'engagent à se conformer aux arrêts définitifs de la Cour dans les litiges auxquels elles sont parties. » Au-delà de l'engagement des parties, le système de la Convention est doté d'un mécanisme de contrôle du respect de ces dispositions. Pourtant, il faut bien le dire, la tendance n'est pas bonne. En effet, la résolution fait état d'un nombre d'arrêts devant le comité des ministres, passant, je cite, de 5231 à la fin de 2019 à 6256 au 1er mars 2023. La Russie, l'Ukraine, la Roumanie, la Turquie, l'Azerbaïdjan et la Hongrie comptent le plus grand nombre d'arrêts de la Cour non mis en œuvre. Nombre de ces pays connaissent des situations de guerre et il apparaît évident qu'ils doivent faire face à de graves problèmes structurels ou complexes pour faire appliquer les décisions. Cependant, ce n'est toujours pas le cas et encore trop souvent, la non-mise en œuvre des arrêts sont le reflet d'une volonté politique, voire d'une réticence à appliquer les principes auxquels l'on a pourtant souscrit. Je mets ici en garde, à la suite d'autres, contre la tentation d'opposer la souveraineté, et singulièrement la souveraineté judiciaire, au respect des principes fondamentaux qui structurent notre continent. Non, la Cour européenne des droits de l'homme ne s'immisce pas dans les affaires intérieures des États. Elle n'a à connaître qu'une partie infinitésimale des affaires. Le juge de la CEDH est avant tout le juge national. C'est à lui de faire appliquer les principes que nous avons tous en partage. La CEDH est une justice subsidiaire. Elle n'intervient qu'en dernier recours et respecte les traditions politiques et juridiques de chaque État représenté ici. Alors, d'où vient cette tentation qui existe dans chacun de nos États, au sein de partis plus ou moins représentatifs, de contester la CEDH et ses arrêts? Tout simplement de pouvoir porter atteinte à la séparation des pouvoirs et porter atteinte à l'indépendance de la justice, chose qu'ils ne peuvent pas faire avec la CEDH. Regardons une fois n'est pas coutume en dehors de notre continent. Le projet de réforme judiciaire en Israël, après d'autres pays, n'a-t-il pas pour but de soumettre l'autorité judiciaire à la volonté politique du gouvernement? Je pose la question. La vigueur de la résistance à ce projet de loi montre bien qu'il s'agit d'une bataille décisive pour la démocratie. Elle nous concerne. Pour conclure, respecter les arrêts et décisions de la CEDH, c'est pour nous tous une garantie que l'état de droit et les valeurs démocratiques seront respectés. Nous ne pouvons laisser les juridictions nationales seules face à des gouvernements qui se raidissent partout dans le monde, y compris au sein de notre propre continent, face aux menaces extérieures mais également aux forces centrifuges qui minent la cohésion des nations. Cette résolution est donc très importante. Il faudra y revenir régulièrement. Je vous remercie.
Thank you. I call next Mr. Çeviköz from Turkey, Socialist. Yeah. You look surprised, but Mr. Çeviköz from Turkey, you wouldn't like to speak? Yeah, you're next on the list. The floor is yours.
Thank you, Madam President. I was expecting David Morris to take the floor, actually. Dear President, distinguished members of the Assembly, allow me first of all to express my congratulations to the rapporteur of this report on the implementation of judgments of the European Court of Human Rights. I imagine that it required a lot of commitment and a very laborious working plan and program to compile such a comprehensive report about many countries. Respect for human rights, democracy and the rule of law are three very important pillars of the Parliamentary Assembly of Council of Europe. Let us also remember the fact, which is reminded to us in the report, that implementation of the Court's judgment is binding on all branches of state authority and cannot be avoided through the invocation of technical problems or obstacles which are due to the lack of political will, lack of resources, or national legislation, including the Constitution. Yesterday, we reviewed and adopted a report and a resolution on European Convention on Human Rights and national constitutions. I find it quite pertinent that the report we are reviewing today is a corollary to yesterday's report. Yesterday's report entails the view that full respect of the Convention and the national constitutional order is not antithetical, but fully complementary. It is therefore necessary to implement in good faith the binding judgments of court in line with the obligations in Article 46, paragraph 1 of the Convention, which are of an unconditional nature and in full respect for the rule of law. I would like to reiterate in that respect that according to Article 90 of the Turkish Constitution, the final judgments of the European Court of Human Rights are also binding. Madam President, dear colleagues, in my country, parliamentary and presidential elections will be held on the 14th of May. I will not be running as a candidate in the elections. So this is, in a way, my valedictory speech in this august body that I have been a part of for the last 5 years. I will always cherish the memories that I have gathered with all my fellow parliamentarians during our endeavors. But I want to mention a very peculiar relevance and importance of this chamber that we are currently in for my country. 19 years ago, on the 15th of December 2004, in this very hemicycle, European Parliament voted with overwhelming majority a very important resolution to approve the launching of accession negotiations between my country and the European Union. Posters and banners in different languages saying, "We, yes or evet in Turkish were raised in the hands of the European parliamentarians. I am certain that after the elections, my country will show up again in the Council of Europe with a strong mandate to reinforce its place among the members of this community of nations, respecting human rights, democracy, rule of law, and with the implementation of judgments of the European Court of Human Rights. So believe you us, we will be with you. I'm sure you are with us too. Thank you.
Thank you. The next speaker will be Mr. Vladimir Vardanyan, EPP from Armenia.
Thank you, Madam Chair. Honourable colleagues, first of all, let me express the words of gratitude and congratulate Mr. Evstafiou for this report. But I would just ask a rhetorical question. Why, after 70 years of existence of the European Court of Human Rights and this organization, we are still discussing the issue of implementation, but rather non-implementation of the judgments of the European Court of Human Rights? Why is it still not a taboo? Why still we cannot say to the states, you know, if you are not implementing the rulings of the European Court of Human Rights, it's a taboo, and this is the final days to you in this organization? Because very often we are actually afraid of different developments in different countries. I don't want to address non-implementation policy of this or that country. I would rather address to the issue how long we are going to tolerate a situation where we as a politicians actually by our inaction undermining the existence of international judiciary. And why we are concentrating on the final judgment? Unfortunately, international justice is a slow one. And very often, to get the real justice, you need also to implement interim measures, which are the basis very often for this or that final judgment. Unfortunately, the Committee of Ministers don't want to be engaged in this process because, you know, it's an additional headache. But you remember, honourable colleagues, that in several resolutions we raised this issue. This is quite important, not to mention only one case. Mr. Chop mentioned Kavala case is quite important, but Mr. Chop, we should also mention other cases. Just a couple of days ago, the International Court of Justice and the European Court of Human Rights adopted interim measures concerning the situation in Lachin Corridor, urging Azerbaijan to immediate states to reopen the movement in Lachin Corridor. Do we have any reaction? Do we have any proper reaction? Inaction of politicians would undermine the very existence of international judiciary. Without international judiciary, we cannot go ahead because our organization is designed to protect the human rights. It's one of the added value of this organization. And if we would continue of having such situation where several countries would be allowed not to implement judgments of the European Court of Human Rights, not to follow interim measures indicated by the European Court of Human Rights, it would be the end not only for the court, but it would be an end for this respective organization, which is quite important for each of us and for the people of our countries. Thank you.
Thank you. I call next Lord George Foulkes, Socialist, United Kingdom. The floor is yours.
Thank you, Madam President. I don't know if you, Madam President, are like me, a fan of mysteries on television. Agatha Christie's Hercule Poirot, who reminds us always that he's Belgian, not French, Bernard. And then Sherlock Holmes, written by from Edinburgh, who came from Edinburgh, Arthur Conan Doyle, as I have come from Edinburgh. Now, I can see some of you are wondering, what's this got to do with the subject of today's debate? Well, I think we have a mystery here. Why is the United Kingdom so critical of the European Court of Human Rights, which it keeps calling in a sort of offhand way the Strasbourg Court? Why? After all, the United Kingdom has the fewest number of referrals to the Strasbourg Court, and even fewer number of critical decisions. So this is the mystery. It surely can't be it, because we're at odds with the European Court in terms of its judgments. And as John Howe said yesterday in his excellent speech, under the Brighton Agreement, and indeed Mr. Bew from France said earlier today, under the Brighton Agreement, domestic courts have priority, and the European Court of Human Rights just elaborates on that. So it can't be for that. So why? Why? This is the mystery. Why is Suella Braverman constantly critical of decisions, particularly on immigration? Now, it can't be because she's against asylum seekers. After all, her ancestors were asylum seekers and were granted permission to come into the United Kingdom. So she must appreciate that. No, the solution to this mystery is that it must be because the court has Europe in its title. And somehow they're antagonistic towards anything that has Europe in its title. Well, my message to her, and I hope all our message, is to Suella Braverman: lay off the European Court of Human Rights. After all, as Christopher Chope rightly said, there are decisions about countries which are 10 times, 100 times worse than the United Kingdom in terms of human rights that should be implemented to protect the people of Europe. So we should be standing up for the European Court of Human Rights. And if Suella Braverman does not follow this example, then she'll end up as a footnote of history, like Theresa May, Liz Truss, and Boris Johnson. Instead of being one of the great people of history, in fact, who had the building that we came through from our palais to here, the building is named after him. Surely she would want to be on the plinth along with Winston, Spencer, Churchill. That is where Britain should be, not in the footnote of history.
Thank you. I call next Madame Isabel Meles from Portugal, EPP.
Merci, Madame la Présidente, chers collègues. Notre Assemblée parlementaire apporte depuis toujours une contribution très importante à la surveillance de la mise en œuvre des arrêts de la Cour européenne, car on considère une priorité ces droits. Pourtant, Osman Kavala, défenseur des droits humain turc qui a participé à la création de nombreux mouvements de la société civile et des ONG dont les activités touchent les droits humains, à la culture, aux études sociales, à la réconciliation historique et à la protection de l'environnement. Pourtant, il a été arrêté en 2017. Il a été accusé de tentative de renversement du gouvernement dans le cadre des événements du parc de Jézid de 2013 et de renversement de l'ordre constitutionnel dans le cadre de la tentative de coup d'État de juillet 2016. La Cour a estimé que cette arrestation et cette détention provisoire avaient eu lieu en absence de d'éléments de preuve, seulement avec le but de réduire au silence et dissuader d'autres défenseurs des droits humains. Le gouvernement turc devait procéder à sa libération immédiatement. La Turquie ne s'est pas conformée à cet arrêt de la Cour et plus que ça, la Grande Chambre a conclu que la Turquie avait manqué à son obligation de se conformer aux arrêts. La non-mise en œuvre d'une décision judiciaire définitive et obligatoire risquerait de créer des situations incompatibles avec le principe de l'état de droit. Le 25 avril 2022, la Cour d'assises de la Turquie a condamné, même après l'arrêt de la Cour, à une réclusion perpétuée aggravée. Il est privé de liberté depuis cette date. Il est difficile de comprendre comment la justice turque a pu conclure qu'il avait suffisamment de preuves pour une condamnation. Les autorités turques ont cherché à contester les conclusions claires de la Cour européenne. Et cette affaire illustre bien les obstacles procédurels auxquels recourt un État pour essayer de ne pas mettre en œuvre en temps utile un arrêt de la Cour, en particulier si ce manquement est dû à une volonté politique. Cette Assemblée devait indiquer que cette situation est inacceptable et menace l'ensemble du système de la Convention. Et là, je suis d'accord et je supporte notre collègue Sir Christopher Schopp et j'exhorte la Turquie et je vous invite aussi à le faire pour que M. Osman Kavala soit libéré le plus sans tarder. Merci.
Thank you. Dear colleagues, I would urge you to take care of the time, so you have a watch, please. Look at it. I call next in a debate Mrs. Elena Simona Spataru from Romania. She's not sitting on her place, so probably she withdrawn. I call next Sir Edward Late, European Conservatives, United Kingdom. Yeah.
Well, Lord Fuchs is a lovely man, but I seldom agree with much of what he says. Of course, he's a fanatical pro-European. There's nothing wrong with that. He's entitled to his views, but he's constantly lecturing us about how the British people made a terrible mistake in leaving the European Union, although, dare I say it, he is an unelected member of the unelected House of Lords, whereas I'm elected by 75,000 people. 60% of my constituency voted to leave, and 17 million people in the United Kingdom voted to leave. And really, when he praises the Court of Human Rights, he needs to surely take account of a very recent case. If you listen to my friend Lord Fuchs, who, as I agree, is a wonderful parliamentarian, and I have nothing against him personally, you would think that we had had no trouble with the Court of Human Rights. Has he forgotten a case that actually I mentioned in this very chamber yesterday? We are facing, has not Lord Fuchs noticed, an unprecedented crisis in the Channel, with boats pouring across the Channel at grave risk to human life, being organised by criminal gangs. So with a mandate from the people, our government is seeking to end this humanitarian crisis. And this is what the Rwanda case is about. In the case of KN v. the United Kingdom, the Strasbourg court granted an interim measure before our own Supreme Court had ruled on the case. The European Court of Human Rights gave no indication that a substantive application had been made to it, most likely because the applicant had not yet exhausted the domestic legal remedies available to him. This basically means the Strasbourg Court has taken upon itself the role of supervising the Supreme Court, our Supreme Court, including overriding its own decision not to grant interim relief, but to let the case follow its normal course in the fullness of time. The government of the United Kingdom had no chance to make a presentation to the Strasbourg Court to put its case. This, Lord Fuchs, is patently unfair and unjust. Interim measures granted by the European Court of Human Rights are themselves extra-conventional. They do not form part of the European Convention itself. But the Court has expanded its own powers in recent years by indicating that so far as it is concerned, the failure to comply with its interim measures will be considered a breach of Article 34. That provides that the ECHR may receive individual applications
and that states may not hinder this. The European Convention is a compact of international law. It is an agreement freely made and freely signed up to by individual states. Any change to the powers of the European Court of Human Rights should be debated and agreed in a transparent manner by democratically accountable governments, Lord Fuchs, and that has not happened in this case. Thank you very much.
Thank you. I would also like to remind again all of us that 3 minutes is 3 minutes, as the President would say in every member state. In the debate, I call next Mrs. Ingjerd Schou, EPP from Norway.
Madam President, the European Court of Human Rights is the cornerstone of our organisation. 675 million Europeans have their human rights protected by our court. Implementation of judgments is fundamental, and the fact that the number of non-implemented judgments has gone up since 2019 is therefore alarming. Being a member, Madam President, of the Council of Europe commits. Judgment from the court can't simply be ignored. So, President, how can we ensure a higher rate of implementation? The work of the Committee of Ministers is key. I agree with our rapporteur that the Committee of Ministers must continue to exert pressure on all member states which systematically doesn't implement judgment. We saw the continuous pressure finally led to implementation of the Mammadov versus Azerbaijan case. And I believe that the same pressure on Turkey can lead to the implementation of the court's judgment in the Kavala case. Madam President, in the draft resolution, our rapporteur encourages closer cooperation with civil society, bar associations and national human rights institutions. This is, in my opinion, crucial. A few weeks ago, the Norwegian Helsinki Committee organised a meeting in Oslo on the future of the Council of Europe. The meeting resulted in the Oslo Statement. The first point in this statement is that the summit must decide on measures to improve the implementation of the European Convention on Human Rights and execution of judgment of the European Court of Human Rights. And, Madam President, the importance of civil society and national human rights organisations was explicitly mentioned. Both the Committee of Ministers and the Member States must cooperate more with these organisations. Madam President, EU accession to the European Convention of Human Rights is no longer a theoretical discussion. Negotiations are in the final stages, and I believe the EU joining will improve the situation of lack of implementation of judgment, at least in the EU member states and states aspiring to become members. The resolution and recommendation which we have on our table are very important. I encourage you all to support them. Implementing judgment is crucial for us to move forward and improve the human rights situation for each and every citizen of Europe. Thank you, Madam President.
Thank you. In the debate, I call next Mr. Arto Gergely, Socialist from Hungary.
Thank you very much, Madam Chair. Dear colleagues, I want to thank the rapporteur for this comprehensive and precise report, even if it is not always joyful. The decisions of the ECHR have a central role in defending human rights. Many times, this court is the last hope of the citizens seeking truth in their personal cases. Implementing the decisions of the court is the test of the rule of law, not only for these individuals, but for the whole public. I am not happy to see Hungary in the list of the worst performing countries. But I welcome that the Hungarian authorities always fulfills its obligation to pay compensation to the individuals, even if they did not agree with the decisions. The problem is with the structural changes requested by the decisions. For example, segregation of Roma children at schools. Secret surveillance and data retention, lack of independence of the judiciary system, and many other issues are not easy tasks to solve and problems for a decade. I think these issues are connected to the general downgrading of the rule of law in Hungary, even there is some progress in some areas, for example, in the issue of the excessive length of the civil proceeding. I want to emphasize that the naming and shaming is not enough. We have to think to improve our processes to create a fruitful dialogue to find the proper solutions. I welcome the report's recommendations in this field. Of course, I know implementing the decisions of the court is sometimes neither easy nor popular. It could be very tempting to make politics against such a type of decisions, and easier to blame the mirror than to face the reality. But I strongly believe, as responsible lawmakers, we still should defend the human rights and rule of law, because their dismantling is a danger to all members of the society in the long term. I want to mention one more topic. I think environmental rights will play a more and more important role in the next few years. The right to life and right to freedom and security cannot be fully achieved without the protection of environmental rights, even though they are not directly part of the Convention yet. I know it will be a long and complicated process to achieve the full recognition of this right, but it's worth fighting for it. Some of our colleagues may say it is an activist or left-leaning approach. I would be proud of both. Thank you.
Thank you. In the debate, I call next Madame Marie-Christine Dalloz, EPP from France.
Merci Madame la Présidente, Monsieur le rapporteur, chers collègues. En vertu de l'article 46 de la Convention européenne des droits de l'homme, l'exécution des arrêts de la Cour européenne des droits de l'homme s'impose aux États membres du Conseil de l'Europe et le Comité des ministres est chargé de veiller à la bonne exécution de ces arrêts. Ce 11e rapport en est l'illustration et je félicite le rapporteur pour la qualité de son travail. Les statistiques qui nous sont livrées ne surprennent pas. Elles reflètent une situation qui évolue peu. 70% des arrêts non exécutés concernent 6 pays seulement, dont la Russie. La typologie des arrêts non exécutés relève que plus de la moitié des affaires pendantes concernent soit des affaires interétatiques, soit des affaires relatives à une limitation abusive des droits et des libertés, soit des affaires relevant de problèmes systémiques qui impliquent soit l'institution judiciaire, soit l'administration pénitentiaire, soit la police, soit les trois, parfois. Monsieur le rapporteur, vous proposez que l'Assemblée parlementaire du Conseil de l'Europe prépare des rapports sur ces cas afin de promouvoir des solutions possibles. J'y suis tout à fait favorable, car trouver des solutions permettant de dénouer ces affaires entraînerait une amélioration bienvenue de la situation. Le projet de recommandation n'appelle aucune remarque de ma part. Ce projet insiste sur les obligations qui incombent aux États. Je souhaite pourtant commenter le point 7.8, qui incite les États à veiller à ce que leur législation nationale renforce la capacité nationale d'exécuter les arrêts de la Cour. Je ne remets bien évidemment pas en cause la primauté des arrêts de la Cour européenne des droits de l'homme sur les décisions des juridictions nationales. J'attire cependant votre attention sur le fait que les arrêts concernant des affaires sensibles peuvent parfois être perçus comme difficiles à accepter par les citoyens. Le sentiment de se voir imposer des décisions supranationales remettant en cause le système judiciaire national est de plus en plus fréquent et engendre un rejet viscéral de l'Europe au sens large, rejet malheureusement entretenu par les formations politiques extrêmes. La démocratie est fragile, dangereusement menacée par le populisme. Veillons à ne pas l'encourager. Ainsi, appeler à une éventuelle modification de la législation nationale peut paraître intrusif. Il me semble que si l'on veut une meilleure acceptation des arrêts de la Cour, il faut également faire preuve de pédagogie, expliquer aux citoyens en quoi une décision vise en fait à permettre le respect des valeurs essentielles pour la démocratie. Il faut constamment mettre en avant nos belles valeurs. C'est à cette condition que les modifications législatives nationales nécessaires pourront être accueillies favorablement. Je vous remercie.
Thank you. I call next Mrs. Sabina Čudić, ALDE from Bosnia and Herzegovina.
Is it working? Thank you, Madam Chair. Well, the implementation of judgments of the European Court of Human Rights, we sometimes may be looking at them as a legal, legislative, or even logistical question. But however, I believe that it stems from, that it's actually, as the report says, primordial political question, and that truly depends on something that we are maybe sheepishly only addressing both in the report but also in this chamber, the question of political pressure and the capacity of this room to place the political pressure on those responsible for implementing the decisions. Burdened by the standard language, bureaucratic language of reporting, it is sometimes necessary to remind ourselves of the basic facts. First of which is that behind every violation of the European Convention stands not naive ignorance or lack of capacities of national parliaments or lack of capacities of the governments or lack of understanding of their obligations, but stands a deliberate political decision and action to violate the rights of its citizens. And this requires political action on our part as well, and not simple recommendations providing support for the nations in kind of placing blame on or placing a responsibility on the civil sector or the non-governmental sector, placing responsibility on the national parliaments. Actually, the governments are the ones responsible. Therefore, capacity of various branches of government to implement court decisions are in direct correlation with the existence of political will. It is the political, therefore, will that produces, ensures, protects the capacities for implementation of the court's decisions and protection of human rights. As the report says, pockets of resistance, and I would add the word stubborn resistance, pockets of stubborn resistance to the implementation of the court decisions produce at least two things. They produce the repetitive cases, as pointed out by the president of the court here yesterday, saying how the backlog of cases and the repetitive cases are actually affecting and overwhelming the court and therefore negatively affecting its effectiveness. And second, perhaps even more importantly, but if not, then at least equally, it hindered courts' legitimacy among the European citizens. In their eyes, they question the legitimacy of the court and the capacity of the institutions responsible for at least the oversight of the implementation, our true commitment to their rights. Finally, I'm encouraged by the although brief conclusion mentioned in the final chapter of the report, talking about the necessity of the political pressure, not excluding penalties, which I think are an effective tool. I'm going to conclude by saying I'm here speaking with a single voice, but as somebody coming from Bosnia and Herzegovina, I truly speak on behalf of thousands, if not millions, of citizens of Bosnia and Herzegovina, each and every one of which is being discriminated depending on which part of territory they visit. Their political rights are taken away based on their ethnic prefix or the lack of their ethnic prefix. Therefore, I invite us all to exercise our capacity for political pressure and to exercise our commitment to protecting what we, at least officially, stand for. Thank you.
Thank you. Please look at the time, all of you. I call next in the debate Mr. Erkin Gatirli, EC from Azerbaijan. The floor is yours.
Thank you, Madam Chair. I, first of all, would like to commend the rapporteur. I am especially grateful to him that he had time to visit Azerbaijan for 3 working days, met with all relevant people in the government, opposition, civil society, defense lawyers. And I'm particularly grateful to our rapporteur that he had had a meeting with me and the chairman of our political party, former political prisoner, Ilgar Mammadov. His name was already mentioned here. He is now fully acquitted, but it was his case in which, for the first time in the history of the Council of Europe and European Convention of Human Rights, Article 46, paragraph 4 was invoked. This is definitely not something that one wishes one's own country to be a leading example, but lesson learned, as the saying goes. This report, at least in the part which concerns Azerbaijan, is very important to me and to many in Azerbaijan, and we're grateful to the rapporteur for detailed information that he provided in the recommendation part. There are some cases which are not yet implemented because they indirectly relate to the outcome of the previous occupation of Armenia of the Azerbaijani territory. Some 40% of them, of the total number of unimplemented cases, and this is reflected in the report. There are cases, there are not that many, of course, which can simply be not implemented until there is a peace between Armenia and Azerbaijan, such as cases Chiragov and others against Armenia, or Sargsyan against Azerbaijan. In the first case, for example, Armenia lost. In the second case, Azerbaijan lost. But to implement those cases, a peace needs to be established. Otherwise, it's technically impossible. Unfortunately, Azerbaijan, yes, indeed, lagging behind in terms of democratic development, and Azerbaijan's human rights record is still rather poor. But there is a very fragile dynamism in the society. Out of 15 former political prisoners in whose case Article 18 of the Convention was invoked, 8 gained full acquittal, and in cases of some of them, restitutio in integrum was achieved. Unfortunately, 7 cases are still pending. I just noticed that I'm running out of time and my time is limited. Thank you very much indeed, Mr. Rapporteur. I will vote for this report.
Thank you. I call next Mr. Onneland from UL, Norway.
Thank you, President. Since the European Court of Human Rights was established, thousands of judgments on cases related to human rights violations across Europe has been issued. However, issuing judgments alone is not enough. Is it equally important to ensure that these judgments are implemented effectively by member states? And I would like to focus on one case that highlights the importance of implementing the court's judgments. This is the case of Osman Kavala versus Turkey. Osman Kavala is a Turkish businessman and civil society activist, detained since November 2017 without any evidence to support the charges against him. Despite multiple rulings by the European Court of Human Rights calling for his release, Kavala remains in prison to this day. In December 2019, our court ruled that Kavala's pre-trial detention was prolonged, arbitrary, and violated his right to liberty and security. The court also found his detention politically motivated and aimed at suppressing civil society and dissidents in Turkey. The court called for his immediate release and adequate compensation for the harm suffered. No single step has been taken by Turkish authorities to comply with the court's ruling, and exactly a year ago, Kavala was sentenced to life in prison after spending many years in custody. This case shows the vital importance of implementing judgments of the court. Not implementing undermines the legitimacy and authority of the court and the entire convention system. Failure to implement judgment also has a devastating impact on the victim of human rights violation. It leaves them without recourse and perpetuates the harm they have suffered. It is unacceptable that Council of Europe member states do not comply with the rulings of the court, and we must hold them accountable. The Kavala case is not unique. Turkey is criticized for failing to implement several judgments of the court, and this has a serious implication for the protection and promotion of human rights in the country. This disregard weakens the rule of law, undermines democracy, and sends a message that human rights violations will go unpunished. We must speak loudly about violation of human rights, regardless of the country in which they occur. Kavala stands with many others as a symbol of people who experience injustice. They deserve our solidarity. We will not forget them. We will use our voice, and we will work to ensure that they experience the justice they are entitled to under our Convention of Human Rights.
Thank you. I call next Mr. Stefan Bergeron from Canada, Observer. The floor is yours.
Merci, Madame la Présidente. Chers collègues, la Commission des questions juridiques et des droits de l'homme de l'APCE a souligné le mois dernier que le nombre des arrêts de la Cour européenne des droits de l'homme, dont le Comité des ministres assure le suivi, est passé de 5 231 à la fin de 2019 à 6 256 au 1er mars 2023. Il s'agit certes d'une tendance inquiétante, mais comme le précise très clairement le rapport du rapporteur F. Statiou, au 31 décembre 2021, 6 pays, et je cite, représentaient à eux tous 73 % des arrêts en attente d'exécution. On ne saurait donc mettre tout le monde dans le même sac. Étant donné que la Russie conserve l'obligation de respecter les arrêts de la Cour et qu'elle présente, et de loin, le plus mauvais bulletin à ce chapitre, j'ai été heureux de constater qu'une recommandation destinée au Comité des ministres avait été formulée en faveur d'une stratégie, et je cite, visant à assurer la surveillance continue de l'exécution des arrêts en attente d'exécution à l'égard de la Russie, ainsi que ceux que la Cour adoptera à l'avenir dans les limites de sa compétence. Dans cet esprit, je souscris sans réserve à la déclaration de notre président d'Assemblée et de notre secrétaire général réclamant de la Russie l'exécution des arrêts de la Cour concernant Alexeï Navalny et la libération immédiate de ce dernier. J'aurais pu vous parler des démêlés de l'Espagne dans la foulée de sa répression du mouvement démocratique en faveur de l'indépendance de la Catalogne, mais je me contenterai, dans le temps qu'il me reste, de vous exprimer mes vives inquiétudes par rapport à la situation qui prévaut toujours dans le corridor de Latchine. Le 21 décembre dernier, la Cour a indiqué que le gouvernement azéri devait prendre toutes les mesures relevant de sa compétence pour assurer le passage en toute sécurité par le corridor de Latchine des personnes gravement malades ayant besoin d'un traitement médical en Arménie et des autres personnes bloquées sur la route sans abri ni moyens de subsistance. La Cour internationale de justice a ensuite ordonné à l'Azerbaïdjan de mettre fin au blocage du corridor de Latchine. Au Comité des affaires étrangères de la Chambre des communes, j'ai proposé une motion qui fut adoptée à l'unanimité demandant aux autorités azéries de rouvrir le corridor et je cite, de garantir la liberté de mouvement afin d'éviter toute détérioration de la situation humanitaire. Compte tenu des graves pénuries qui perdurent et qui s'accentuent dans le Haut-Karabakh, je veux que nos collègues azéris comprennent que le monde n'a pas oublié ce blocage inacceptable qui contrevient aux termes du cessez-le-feu auquel leur pays a pourtant souscrit. En guise de conclusion, le rapport du rapporteur F. Statiou souligne le fait, et je cite, qu'une bonne proportion des affaires de la Cour européenne des droits de l'homme en attente d'exécution en Azerbaïdjan concernent les conséquences de ce conflit. Je me joins donc au rapporteur pour exhorter l'Azerbaïdjan à mettre en œuvre, ces arrêts de la Cour qui relèvent, précise-t-il, je cite, de la démocratie et de l'état de droit. Je vous remercie de votre attention.
Thank you. And the last speaker for tonight will be Mr. Yildiz from Turkey.
Thank you, Madam Chair. Once again, Turkey is being criticized here in a discriminatory manner. I am frank about this. First of all, the verdicts of the court are binding for all